Hello. Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today we have the pleasure of hearing from Joe Bodiford. Joe is board certified in criminal trial law, as well as board certified in criminal trial advocacy by the National Board of Trial Advocacy. Today we're going to be speaking about discovery and pretrial ethics in criminal cases. Joe, welcome. Thank you for joining us.
Good morning. Glad to be here.
Great. Let's just go ahead and get started. Once an attorney has taken a criminal case, what are the main ethical issues he or she should look out for?
Well, the biggest is going to be diligence. Communication with the client, diligently investigating the case. Those are things that come up in every single criminal case. It's easy to, sign the retainer agreement and make the deposit and kick back and wait for the state's discovery disclosure to come in. But there's a lot more to that. And I think being diligent is being very mindful to look at all aspects of where discovery can come from. Look at perhaps doing public records requests. Look at hiring an investigator to go out and talk to folks on the street. Make sure you have plenty of meetings with your client so that there's meaningful communication back and forth. That's the only way you're going to resolve really any case. And I think that's the biggest ethical concern in a criminal case.
Okay. Are there any special ethical issues or duties in discovery in criminal matters?
Well, there are, and there's two big things that come to mind. The first would be a prosecutor's duty. We have Brady versus Maryland, which is codified not only once but twice in our discovery rules, and also it's a special rule for prosecutors in our bar rules, that prosecutors have to disclose any evidence that tends to negate the guilt or perhaps establish the innocence of a defendant. And it brings to mind the movie Cape Fear, where that became an ongoing problem over many decades. But I caution young prosecutors, if in doubt, go to a supervisor, take the piece of information, and see if it's going to fit within that very broad definition that Brady establishes. As far as defense attorneys, if you're going to use it at trial, you got to disclose it, and you got to disclose it timely. If there's a violation, the judge will have what's called a Richardson hearing to determine whether or not your noncompliance with the discovery disclosure rule was either willful or inadvertent, and whether it's significant, or if it's just one that's just really no big deal. Timely disclose what you have. And there is also a new case from the second DCA, it's actually from last year, Kidder versus State, that very specifically interpreted the discovery rule for defense attorneys and experts that says if you hire an expert and that expert writes a report, whether or not you're going to use that report, you got to turn that report over. So be very careful in hiring experts. Make sure you talk to them before you decide you're going to use them and a report is rendered.
What if they don't render the report? No written report?
There's no written report and there's no intent to use them. I think that in that situation, Kidder and the reading of the rule would not require disclosure. But if a report is given, it has to be turned over.
What types of conflicts of interest commonly arise with clients?
Well, I think the biggest one we see, because of the nature of criminal defense practice, is going to be where the client stops paying the bill. I think the bar rule would require you to render as much service as has been paid for. So be very careful about, as soon as the first installment payment is not in, that you don't file a motion to withdraw the very next day. Make sure you've done enough work to justify the fee that you've taken. That does indeed complicate the attorney-client relationship. Also, something that comes up, as we mentioned in one of our other videos, is clients that get in trouble once and you're representing them, and then they get another arrest and another arrest. Those subsequent arrests can indeed hurt the attorney's ability to represent the person on the first one, and perhaps could be a reason for withdrawal. In my retainer agreement, I tell clients that I expect them to abide by the law and respect the law and not commit any new crimes while I'm representing them, and if they do, that can be grounds for me to withdraw. And I guess the other thing beyond that is clients that just tend to want to insist on a course of conduct that is repugnant to the attorney, I think is what the rule says. If those situations arise, I advise all young lawyers, or really any lawyer that's got a case, call the bar hotline. Call the Florida Bar Hotline, speak to an ethics attorney, and actually you can get the call number and keep that number for your own reference later on to show that, yes, I did call and I got some advice, and follow the bar's advice.
And with that, it has to be that lawyer's own conduct, not somebody else. You can't call for a friend. It has to be your own future conduct.
That is correct. That is correct. And you can do it anonymously, or you can give them your name. But either way, you can get the record of the call for your records.
All right. Thank you, Joe. And that concludes this video for Mentoring with the Masters. Thank you for watching.